Looks like everyone might be ready. We'll start with the appellants. Mr. Ronald Gossett is here and going to be arguing first. Is that correct?
That's correct, Your Honor.
Mr. Justice Apple, can you hear him?
I can, thank you.
Thank you. And if you'd want to turn your mic off for a moment, I would like for Mr. Armentrout to give a sound check quick.
This is Armentrout, check.
Thank you very much.
Thank you. Okay, when ready, it's my understanding Mr. Gossett will argue for the first portion of the appellant's time, and then Mr. Preston will take over. Is that correct?
That is correct, Your Honor. And Mr. Preston will be arguing from the center podium. Does he need to do a sound check?
Yes, that's a good idea.
Started?
Thank you. You'd make a good IT guy. Thank you. If you'd like to come forward, Mr. Preston, we'll do one more sound check.
Justice Apple, can you hear me?
I sure can. Thank you very much, Counsel.
Thank you.
Alerting me to that. And then, of course, Mr. Armentrout will argue then for Appellee. Okay, you may begin, Mr. Gossett.
Madam Chief Justice, Associate Justices, and Counsel, may it please the Court, I'm Ronald Gossett, appearing on behalf of about 250 doctors of optometry and dentistry from 27 states, not Iowa, and their business entities. Mr. Preston will be arguing on behalf of his clients, which are 21 similar doctors of optometry and dentistry, and we are going to discuss a little bit different issues. If you ask me a question that I think is best answered by Mr. Preston, I certainly will step aside and let him do that. I wanted to begin with the issue of personal jurisdiction. Personal jurisdiction was highly litigated in all courts. It began when the collection actions were filed in Iowa State Court by the predecessor to PSFS 3 Corp, a company named NCMIC Finance Corp. That I will refer to as NCMIC just from years of calling it such. When NCMIC filed their collection actions in Iowa State Court, I was preparing a putative class action to file in the Federal District Court in Southern Florida. When I filed the action, there had been about 7 of the existing collection actions filed in Iowa State Court by NCMIC, making an allegation of personal jurisdiction in the petition that the parties had agreed to jurisdiction of the Iowa courts. The petition contained a copy of the contract, and the contract did not support that allegation. In fact, the contract made clear that there was no agreement between the original parties to the contract over jurisdiction. The only agreement to jurisdiction in that contract was if the contract was assigned, then the parties would agree that the state where the assignee's principal office was located would have jurisdiction. Once I filed the Federal District Court action in the Southern District of Florida, I sent a copy of it to Ed McConnell, counsel for NCMIC at the time, and advised him that the petitions that were filed in Iowa contained an improper allegation and suggested that he needed to read the contract again to see that there was no such agreement to jurisdiction. We subsequently know through production of an email, the attorney-client privilege aspect of that email was waived by NCMIC when it submitted the email or forwarded the email to its lender, Wells Fargo. We know by that email, which is at volume 7, page 121 of the record, that Mr. McConnell agreed the contract did not contain that agreement of personal jurisdiction as he had alleged, and suggested to NCMIC that they manipulate jurisdiction in this fashion. They create a new corporation in Iowa and assign all of the contracts to that new corporation, thus triggering the floating jurisdiction clause. When we were confronted with the improper allegations in the collection actions, we filed a motion to dismiss for the failure of having personal jurisdiction. We argued that orally to the Iowa District Court, and the Iowa District Court denied.
Counsel,
Yes, sir.
Sorry, if I might on that point, were there any restrictions on who NCMEC could assign this contract to?
There was no restriction expressly in the contract, but there would be by in every contract in Iowa and most states contain the implied covenant of good faith and fair dealing. So constraining the type of assignment that would be acceptable would be one that falls within the implied covenant of good faith and fair dealing. We're told by the financing industry, and it seems to have been borne out over decades, that the financial industry needs to be able to assign financial instruments to maintain liquidity. If they find themselves too heavily invested in one industry, for instance, they may need to assign those contracts, get out of their deep position in that type of an industry. So we know that contracts need to be freely assignable. And in that situation, if NCMEC had gone outside of its realm and gone to another lender and wanted to assign these contracts to another lender to maintain some form of liquidity, that would have been totally acceptable. But that's not what happened. What happened was NCMEC violated that implied covenant of good faith and fair dealing. Matter of fact,
Didn't the contracts state that the lessor's home office was in Des Moines, Iowa, and that they were governed in effect by Iowa law already? I mean, wasn't there already kind of an Iowa locus to these agreements before they were assigned?
I think that's a little bit too broad. The contract provision that you're referring to was the choice of law provision. Yes, the contracts contained a choice of law provision that the body of law found in the lessors, which would have been NCMEC, which would be Iowa, or the lessor's assignee, again Iowa, would be the law to be applied. And in fact, the law of Iowa was applied for these contracts in the Southern District of Florida throughout that litigation. But the choice of law is different than a consent to jurisdiction and a submission to jurisdiction. The parties, without question, agreed to applying Iowa law, but the parties, without question, did not agree in that initial contract that there would be any particular.
What about the home office? Wasn't that disclosed, that the original lessor was based in Des Moines, Iowa? Wasn't that also disclosed?
Yes, sir, and therefore the law of Iowa would apply. But there was no provision in that contract that said because NCMEC was located in Iowa that you would be submitting yourself to the jurisdiction of the Iowa courts in litigation. In matter of fact, you would look, now this is a bit theoretical, I believe. A lawyer practicing in this area knows that most businessmen, particularly doctors, don't negotiate every particular point of the contract. But we, looking at contracts from a legal theory, have to give credence to that idea that every point is negotiated. So here you have NCMEC submitting to the doctors a form which it prepared, which contained no agreement to litigating in Iowa. So the doctors would have every reason to believe that if there was going to be litigation with NCMEC, it would be in a state that would satisfy that state's long-arm jurisdiction laws, as well as the long-standing principles of international shoe and other jurisdictional cases. NCMEC found that their contract had an error in it, and they set about to unilaterally change the field to correct their error. Rather than just admitting this was an error, we'd like to do it this way, have some form of an agreement at that point, they tried to manipulate it. And the federal district judge who denied NCMEC's motion, NCMEC by this time was also joined with PSFS 3 Corp in the Southern District of Florida. She denied their motion to dismiss based upon what they alleged to be a clear mandatory forum selection clause, which required the litigation to be in Iowa. A position, by the way, that NCMEC had taken in the hearing on the judicial panel of multi-district litigation. We had filed, there were several different federal district court actions pending throughout the country. We filed a petition to transfer all of those into one transferee court. In the response to that petition, NCMEC took the position that, NCMEC and PSFS 3 took the position that because of this floating forum jurisdiction clause and because of the assignment of these leases to PSFS 3, yes, they agree that a transfer is in order, but the transferee court must be Iowa, not Florida. The MDL panel disagreed, and the MDL panel transferred all of the cases to the Southern District of Florida. So by the NCMEC and PSFS 3 Corp had filed a motion to dismiss in the federal district court. And she denied, the federal district judge denied the motion to dismiss, making a finding of fact about this transfer, about the assignment, saying that the court should decline to enforce a mandatory forum selection clause because we have shown that a transfer would clearly contravene the interest of justice. We, the plaintiffs in that court, filed their action before the agreements were signed, and it would be inequitable to allow the defendants to shop the actions to another forum simply by assigning the leases after the lawsuit is filed. And that's all that happened here. Now, August 12, 2010, the MDL panel issued its ruling transferring to the Southern District of Florida. On that same day, the Iowa District Court issued an order denying our motion to dismiss. We sought an interlocutory appeal of that. This court denied our application for an interlocutory appeal, so that order remained interlocutory. The decision of the federal district judge also remained interlocutory throughout that litigation. That final judgment in affecting these three-column PSFS 3 clients was appealed by us to the 11th Circuit Court of Appeals. It was not cross-appealed by NCMEC and PSFS 3. It was not cross-appealed because they had a favorable result, but they can't divorce the favorable result that they got on the enforceability of the contracts from the jurisdictional issue that the court had decided. The 11th Circuit affirmed those final judgments, which then gave us issue preclusion on the issue of whether or not the Iowa court had jurisdiction.
Counsel, isn't a motion denying a transfer based on a number of factors, including convenience? Do I understand correctly, it does not necessarily mean there's no personal jurisdiction in Iowa, just for a combination of reasons, we're going to leave this litigation in Florida?
It could very well have done that, but there was no decision by the judge on any other ground other than whether or not the assignment done simply for the manipulation of jurisdiction should be given effect. Now, when the federal district court then said she had jurisdiction over these cases, the federal rules of civil procedure would apply. And there is a rule of procedure which requires compulsory counterclaims. The enforcement or collection actions that NCMEC was filing and PSFS 3 was filing here needed to be raised as a compulsory counterclaim in the federal district court. It was not done. We went all the way through the affirmance by the 11th Circuit Court of Appeals without NCMEC or PSFS 3 ever raising a compulsory counterclaim. The result of that is that the compulsory counterclaims are lost. They no longer have that right.
Does it make a difference that they had those claims by then were pending in Iowa?
It would if the claims that were pending in Iowa were appropriately pending in Iowa. They can't just...
It was not really before us about the compulsory counterclaims because we're not reviewing anything there. We're just deciding whether there's personal jurisdiction in Iowa, correct?
Yes, but it was answering the Justice's question about, in fact, couldn't she leave state court actions pending without it necessarily violating the compulsory counterclaim rule.
Your position is that there was a determination in Florida that the assignments were not enforceable for purposes of determining personal jurisdiction, and that determination should have collateral estoppel effect here. Is that what you're saying?
Yes, sir. A little bit finer tune on that is the federal district court made a finding that dovetails exactly with the U.S. Supreme Court case first agreeing to enforce form selection clauses as MS Bremen.
Usually those clauses, they want to go to Florida.
Yes.
Like the cruise ship case, but
This is
not
true.
here.
This is true. We have, in the MDL action, we happen to be on the docket with the Gulf Horizon cases, and the courtrooms in the federal building in Boise, Idaho, filled with lawyers, and most of them wanted the cases to go to Florida. The importance, Justice, of the finding by the federal district court is that that finding is dovetailing exactly with what MS Bremen says you must find to not enforce a mandatory form selection clause. And the MS Bremen case was cited with approval by the Iowa Court of Appeals. And the criteria in MS Bremen and cited by Liberty Bank in 2007 by the Iowa Court of Appeals is that enforcement of the form selection clause would be unreasonable under the circumstances. And in this case, the federal district judge finding that to enforce the mandatory form selection clause would clearly contravene the interest of justice and would be inequitable to allow the defendants to form shop, we think fits into the matter of it being unreasonable.
You may wrap up on the appellant side.
I see that my time has expired. I will just rely upon my briefing for all the other issues we've raised.
Thank you. Mr. Armentrout, when you're ready.
Would Mr. Preston be able to go first with his?
I believe the time that was on the clock was the full time for appellant. Am I correct? Yes? Okay. That was, I think that's your responsibility to divide that time up. Sorry. But you'll get the last word. Mr. Armentrout, you may begin when you're ready.
May it please the court, counsel. I represent PSFS 3 Corporation of Clive, Iowa.
I'm sorry, I can't hear you, Mr. Armentrout.
How about now?
There you go. Thank you. Yep.
If you want to start over, go ahead.
Okay, I represent PSFS 3 Corporation of Clive, Iowa. Finality is one cornerstone of our system of justice. Another cornerstone is the fair opportunity to present your case to a court of law. It's to get the bite at the apple. And in this case, after 11 years of litigation in 2 states, the lessees have had so many bites at the apple, nothing is left but a core. It is time for finality. Since this court decided the Wolf case in 2011, courts in Iowa have routinely enforced agreements which are considered sales with security interests. And that's exactly the kind of agreements we have in this case. It's the same case, the same agreement that we had in Wolf. And it's not disputed in this case that nearly every single lessee admits signing the agreement, receiving the equipment, receiving the financing from NCMEC here in Iowa, making payments, some as many as 30 monthly payments, stopping the payment flow, and placing them into default. So I would submit—
Wasn't there a reason they stopped, though? Something to do with no more marketing or something like that, if I remember right in the record?
Right, yep. A defense heavily litigated in Florida in the declaratory judgment actions when their defenses was that Brycan, the vendor from Florida, had fraudulently induced them into entering them and promised a side agreement. There was a group of lessees that the Florida court divided off that are not at issue in this court. That defense was ruled by the Florida court not to stop the enforceability of the 3 common leases, which is the 300 that we have here, Your Honor. But I would submit that if this case were just one agreement with one lessee, the Iowa court would have resolved it on summary judgment back in 2010, or at least in 2011 when this court decided Wolf. And it should not matter that we're dealing with 300 lessees because nearly every agreement, save one, are identical in this case. The reason we submit that we're here in 2021 still arguing this case is because the 1,400 lessees back in 2010 pooled together their resources, put together a gigantic war chest to defend the case, and hired lawyers that launched a scorched earth defense.
Well, let me ask about the personal jurisdiction
Yes.
issue. The suggestion is made that the Florida court, in fact, authoritatively ruled on that, and that you are precluded from relitigating it. What exactly did the Florida court do? Was it a discretionary call, or was it an actual ruling related to the personal jurisdiction issue?
What was at stake at that time in Florida in that motion? It was a motion to change venue. And what the Florida court was deciding under a federal venue statute, it's 28 U.S.C. 1404, is decide whether the Florida court could proceed with that venue or not. And as was pointed out by, I believe, Justice Waterman, there's many factors that go into that, one of which is whether there's a forum selection clause in the agreement and so forth. What was not decided by the Florida court was whether the Iowa court lacked jurisdiction. That certainly wasn't before the court. There was no discussion in that decision about the assignment to PSFS 3. In fact, if you read carefully the Florida court decision, it's by Judge Seitz, she actually noted that Judge Huppert in Iowa was the judge appointed to the consolidated cases here. And she wanted to make sure to stay in her lane and understand that those cases could proceed in Iowa. And she stated in the same decision that Judge Huppert had denied the motions to dismiss for lack of jurisdiction, concluding that the forum selection provisions in which defendants acceded to jurisdiction in the assigned BRICAN and PSFS 3 agreements were not unreasonable, unjust, or brought about through fraud. The Florida
Okay,
court,
now let's move then to the next part of your adversary's position, and that is that, well, I mean, you heard the argument and you've read the briefs. That is that under the original contract, it didn't clearly establish, or there was no agreement for jurisdiction in Iowa. And so the purpose of the assignment was lacking in good faith. The purpose of the assignment was basically to fix the prior contract, and that under the prior contract, although there was a choice of law provision, there would not be personal jurisdiction in Iowa. You understand the argument, but I'd like to hear your response.
Yes, Justice, I do understand that argument, and it's been briefed pretty much for 11 years and argued. In fact, it was raised 5 separate times to the Iowa courts and denied each time that very argument. But I would like to start on that argument to the point that the original agreements were all with an Iowa company. It does state exactly on the top, on the front, that the lessor is PSFS of Clive, Iowa. So it was not a surprise that to any of the lessees throughout the country that were signing these agreements that they were dealing with an Iowa company. And
so would there have been personal jurisdiction without the assignment in Iowa?
That's, of course, somewhat speculative. I think there probably would be under the current case law, considering the number of payments. Some, as I mentioned, as many as 30 payments were made to an Iowa company. There were collection and administrative efforts. The contract was partly performed in Iowa. But that was never an issue because the court originally in 2010, Judge Huppert found that there was nothing nefarious about the assignment that happened back in 2010. And so he concluded there was Iowa's jurisdiction based on the forum selection clause.
Let me ask this. Was the purpose of the assignment to establish clearly personal jurisdiction in Iowa?
Yeah, PSFS 3 has never shied away from the fact that the agreement is clear. It states what it states. It states upon assignment, the assignee would have jurisdiction. And so they created an entity, and as Judge Huppert has decided twice, a legitimate entity that was designed to facilitate and handle the portfolio of the 3-column leases. That litigation, that issue, of course, was raised by all the lessees back in 2010, and Judge Huppert took a look at it, said it was not a sham assignment. In fact, I know there was a question with regard to whether the assignment, the agreement could be assigned, and in fact, right in the agreement itself, at paragraph 10, it says that we have the right to assign this to you without notice. So the agreement does permit such an assignment. Judge Huppert, after ruling that the assignment was legitimate and that the personal jurisdiction would be in Iowa, didn't deter the lessees. They decided, again, I believe, through scorched earth type efforts, they took discovery. They deposed the president of PSFS 3 after that. They renewed their motions the following year in 2011, again attacking the assignment between NCMEC and PSFS 3 as somehow a sham. And again, Judge Huppert, on an expanded record.
Yeah, it wasn't. Frankly, I don't think it was a sham in the normal sense. And, you know, there was talk about piercing corporate veils and all this, and that frankly, doesn't persuade me much. But, and I appreciate your candor, and you've taken this position all along, namely the purpose of the assignment was, in fact, to establish a basis for personal jurisdiction in Iowa. And I think the other side says, oh, that's bad faith. And I think you say, well, read the contract. Do I fairly summarize? I mean, read the contract. The contract says we can assign. And the purpose of the assignment to establish personal jurisdiction in Iowa is beside the point. The assignment is, or the assignment provision of the contract is unqualified. It says we can assign it to really whomever. And so that's it. Now, am I fairly characterizing the dispute?
I think you are, Justice Apple. I think that is it. I think there's a little bit more to it. The fact that the assignor and the assignee are both Iowa companies, it's the second part of the test is once a prima facie case of jurisdiction is established, the burden shifts to the other side to show that Iowa is somehow unreasonable, unjust. It's so gravely difficult that you don't get your day in court at all in Iowa. And because you have two Iowa companies, one assigning to the other, this is really the opposite of forum shopping. And so, and again, Judge Huppert again denied the motion to dismiss based on jurisdiction in 2011. When the cases returned to Iowa in 2017, in May of 2017, we filed a motion for summary judgment. Among the issues in the resistance was lack of jurisdiction and the assignment again to PSFS 3. October, the lessees filed their own motion for summary judgment based again on lack of jurisdiction. Both of those denied by the district court. And then at the bellwether trials in December of 2017, the lessees again raised lack of personal jurisdiction. And this time Judge Rosenberg in his April 2018 decision again denied that the Iowa courts lack jurisdiction. And really, if you take a look at the proceedings that happened in 2017 through today, it's clear that the Iowa courts did handle these cases on the merits and that it was not unreasonable or unjust for the lessees to litigate these, what really are fairly simple contract matters to judgments here in Iowa. In fact, the Florida lawyers that were involved were welcomed here by all the judges. I was at all the hearings from 2017 on, and they were able to come up for every single hearing and the two trials in this case. And so we believe the Iowa jurisdiction was proper through the forum selection clause. And further, with regard to the Florida action, the Florida court there, it was always understood that the cases which had been filed in Iowa in 2010, which end up being stayed to await the ruling from Florida on the defenses, the common defenses, even Judge Seitz in Florida, when she sent the cases back, even noted in her ruling on the judgments of 2015 that all the claims between NCMIC and the three-column plaintiffs have been fully resolved, and NCMIC intends to apply these judgments in the Iowa actions. In fact, the Florida judge, we believe, was coordinating with the Iowa courts here because of the number of cases and the processing. She actually sent an instruction in the same order to the Iowa courts on helping to apply her rulings in there. If the courts, if you read her decision, volume 1 of the appendix at 946, plaintiff's claims against Brycan will not affect the enforceability of the financing agreements or the finality of these judgments. In fact, we felt that the Florida judge's rulings were so clear on it in granting summary judgment on this group of leases, the three-column leases, that we actually asked Judge Rosenberg to simply grant summary judgment and enforce those the Florida judgments here in Iowa. And the reason we did that was because we believe some of the new defenses that were being raised were common defenses in Iowa in 2017 that could have been raised clearly in Florida. As Mr. Gossett pointed out, the Florida judge did apply Iowa law to the three-column leases, and issues such as whether interest rate needs to be disclosed in the agreement under Iowa Code 535 should have been raised in Florida, could have been. There were 5 years of litigation down there. Judge Rosenberg went ahead and addressed all those issues on the merits and denied those here. We believe with regard to those disclosures that this court in the Wolf case set a pretty clear precedent on that, and we don't think that case should be overturned at this time.
Would we have to overturn Wolf in order to get the relief they request on the interest rate issue?
I believe so, Your Honor. Again, our agreements in this case are sales with security interest, exactly the same as the agreement that was in the Wolf case, and we actually put the Wolf agreement in our appendix as well. It's a matter of public record. It was in this court's appendix in the Wolf case. And so that is still good law. There's never been any cases. We've seen no cases cited anywhere in the country with regard to any other state's disclosure laws that require disclosure of interest rate on a commercial sale and security interest agreement. So we believe.
Could you give your elevator speech on the defendant's argument that damages, that they were not allowed an opportunity to present evidence on the damages?
Sure, yeah. Your Honor, the only thing PSFS 3 is seeking are the remaining payments and default interest. We were going to make it as easy as possible for Judge Rosenberg after the bellwether trials, he ruled in our favor in granting our summary judgment motion to calculate those damages. And it has been undisputed since 2010 of what the remaining payments are. We took late fees and taxes out because there were some issues with regard to whether those should be awarded. And so by only seeking the remaining payments, when we filed a motion to enforce the court stipulation, provided a spreadsheet that showed the remaining payments by each one of those lessees. It was the same information we had provided in discovery. We filed that in May. There was no response to it. To this day in this court, there's been no response or a dispute with regard to the number of remaining payments that need to be made. They certainly could have done that at the December 2018 hearing. When the court asked them about it, they did not. They could have responded to the proposed judgments. They did not. They filed a 56-page motion to enlarge after the district court entered some of the the judgments in 2019. In that 56 pages, there was not one reference to the number of remaining payments. So we believe they have had a fair and full opportunity to respond to that, and we're asking for a simplistic method to calculate damages. And my time is up, and I would ask that the court please put some finality to this and approve and affirm the district court's judgments in this case.
Thank you. Will it be Mr. Gossett or Mr. Preston?
I'm going to briefly respond to the jurisdictional issues and turn it over to Mr. Preston for the issue with respect to Wolf. Justice Apple, you asked about whether or not Judge Seit's ruling was on a ruling or was it just exercising her discretion. And Mr. Armentrout referred to the ruling as being on a motion to change venue. In fact, the motion that was filed by NCMEC and PSFS 3 was to dismiss the federal court action for lack of subject matter jurisdiction in light of the assignment and the forum selection clause, and as an alternative to change venue. So the ruling and the litigation was on whether or not the Iowa court or federal district court in Florida had jurisdiction. Justice Apple, you asked about couldn't there be...
Could I follow up on that
Yes.
point real quick? Is this the ruling that's in Appendix 1 at 284 to 286 in that area? Because we can then read it and interpret it ourselves. Right?
It is, yes, Appendix 1, 286.
Thanks.
Justice Apple asked, couldn't personal jurisdiction rest on some other basis other than the form selection clause? And I would say in response to that, Justice Apple, the answer is not in these pleadings. The only issue for personal jurisdiction that was raised in the petition was contractual. There was no alternative allegation in the petition about a long-arm statute bringing into Iowa the defendants that were residents of other states. There was no effort or opportunity to litigate whether or not International Shoe and its progeny would be satisfied by so doing. So the only answer to the question about jurisdiction has to be found in the contract and nothing else. Last thing I'll address is the remaining...
Let's assume the assignment was made for the purposes of bolstering the claim of personal jurisdiction, which I don't think is disputed. Under the Iowa law of good faith and fair dealing, why does that matter? I mean, if our law deals with performance and prevention of performance and doesn't imply new substantive terms into the contract, why does it matter that the assignment was made for the purposes of strengthening a jurisdictional claim versus providing liquidity for the parent company? Those both are legitimate interests from the corporate perspective.
I would say that the assignment was not done to bolster the jurisdiction. It was done to gain jurisdiction in Iowa. And I find that to be taking away from the bargain that was struck, there being no...
Well, but the bargain included a specific provision that permitted the assignment. And so they haven't really breached a term of the contract, I don't think. Indeed, there's a term of the contract that on its face at least says they can do this. And I'm trying to figure out how, when you comply with a term of the contract, you also have a violation of duty of good faith and fair dealing. That may be where Justice McDonald was heading to.
Well, I believe, Justice Apple, that the reason that it matters is they're not simply exercising a right under the contract, they're exercising that right for an improper purpose. The improper purpose is forum shopping. No court in Iowa that I'm aware of has said it's okay to shop a forum. It is still something that courts throughout the country, including Iowa courts, find to be an anathema. We do not want litigants to be shopping for their best bet someplace and trying to get there however they can. And that's the only reason. We know that. That's not speculation. Look at what Mr. McConnell wrote to Mr. Cole in volume 7, page 121. He says, if we will do this, we can get the cases in Polk County in the district court where we have built up a body of law over the last 5 years that enforce these contracts. If we have to litigate it in other states, we might lose. So it's forum shopping, and that's why I believe it violates the covenant of good faith and fair dealing. I need to stop so Mr. Preston can get to Wolf. Thank you.
May it please the court. And I'll obviously be brief. Chapter 535 claims were expressly found by the Iowa District Court to remain justiciable in this court. That's at the appendix, volume 6, page 271 of its ruling. Chapter 535 requires, even of a business, that an agreement to an interest rate beyond 5% be agreed to in writing, and it uses the term rate of interest. A party cannot agree to a rate of interest in a writing if that writing does not express a rate of interest, or if that writing does not provide the building blocks from which an intelligent commercial investor may determine a rate of interest. Wolf does not, and I'm past the time, may I just complete this? Thank you. Wolf does not stand for the proposition. It certainly does not seek to overturn or not give credence to Chapter 535 as it cannot. It must be read in a manner that is reconciled to Chapter 535, specifically subsections 2 and 17. Those sections require that even for a commercial party, that there be an agreed to in writing rate of interest. That word rate appears in sections 1 through 6. It appears in 11. That cannot be met if all the party, including a business party, knows is that they're signing a document that says how many payments they'll make and over how many months. A party cannot agree in writing to a rate of interest if that writing does not contain a rate of interest. It's that simple. And Wolf cannot be interpreted in a manner that would eliminate the absolute directive of Chapter 535, again, specifically sections 2 and 17. And if a rate of interest is not agreed to, which is clearly by subsection 2 made a material term, then under subsection 17, you cannot satisfy the statute of frauds because by definition, statutorily, there is missing a material term under subsection 17, the statute of frauds section, and therefore the entire agreement is unenforceable. Wolf has nothing in it that would contradict that fundamental analysis. Wolf simply indicated that the requisite building blocks by which that commercial party could have determined the rate of interest were present there. Those building blocks were not present here. There was no possible determination of a rate of interest, and therefore 535.17 had to have been violated by this agreement. Thank you.
The matter of PSFS 3 versus Seidman et al. Is hereby submitted. And as stated at the beginning of this morning's arguments, the third case of Iowa Supreme Court Attorney Disciplinary Board versus Newport is also hereby submitted. Bailiff, you may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.